What are the misconceptions about the workers' compensation process in North Carolina? Attorney Kevin Ginsburg explains. The most common misconception is that people might think that they are entitled to a lot of money beyond getting their medical treatment and beyond a rating and their time out of work. Workers' compensation was not created to make people rich. It was not created to make people better off than they would have been if they were not injured on the job. It was created to come close to making people as well off financially as they would have been if they were not injured. It was not even created to make them whole. Indeed, you see that people get 2/3 of their average weekly wage and not the full amount of their average weekly wage. So it was created as a compromise between unions, employees, and businesses to try to provide some safety net for workers. There is no entitlement for pain and suffering in any way, and no one will ever get any money for pain and suffering within workers' compensation. That said, when you clinch your case, you might sometimes get more money than you were entitled to because you were biting off the risk of future treatment. You might feel like that is for pain and suffering, but it is not. That is for other things, such as future medical treatment and lost wages that the insurance company no longer has to pay for because of a settlement. So there is no pain and suffering in workers' compensation. Another misconception, sort of on a happier end from my side of things, is that the fault does not matter. You don't have to prove anyone was at fault for causing your injury, and in fact, even if someone was at fault, that is legally irrelevant and does nothing to increase the value of your case. You also don't have to worry about whether or not you were at fault. We do not have the obligation to prove that the employer is at fault, and a lot of times clients might be upset because they feel like their boss or supervisor was at fault for causing their injury. And while that might add insult to injury, it does not add any value to the claim or change the way the law interacts with your claim. That fault is irrelevant. On the flip side, the good part about that is you do not have to prove that your employer was at fault. Another good part about that is, even if you were partially at fault, even if you were 100% at fault, even if you were driving 100 miles an hour, that claim is still covered as long as everything else lines up. For a free phone consultation, contact attorney Kevin Ginsburg in Durham, North Carolina at 919-407-8511 or visit www.personalinjurydurham.com.